here at Court TV. Let's talk about it with trial attorney and host of Once Upon a Crime in Hollywood, the podcast, Kelly Hyman. She's in Miami, Florida, and national trial attorney Michael Jaafar. He is in Michigan. Mike, we don't know a ton about the state's case. We know that there, was some bloody clothing found at him, and they zeroed in on him shortly after the incident because you had all these people coming out of the woodwork saying, oh, you got to look at him because she was scared of him. At the end of the day, it's easy to point fingers at the person that was that guy that, she was scared of, but there's got to be more to it than that. And I guess the bloody clothing is going to be real big.
I fully agree. And my opinion on these investigations now has changed in the past 10 years. And here's why. Here's what I'm going to say. The police and the detectives who investigated this know things we don't know. I'm assuming, this is a prediction, I'm assuming that there's a bunch of forensic evidence, telephone evidence, tracking evidence that we don't yet know, but we're going to find out about soon. Because for them to, arrest the guy, the overwhelming majority of people who are arrested in murders like this end up getting convicted. Why? Especially these days, because the overwhelming amount of investigative tools that investigators have far surpass what we had 20 years ago and what we had growing up. So we don't know much, but we're going to find out a lot. Yeah, the bloody clothing is going to be a big deal. They've undoubtedly ran tests, but there's other stuff that have connected him to this murder. We'll find out about it.
What about the Drew Carey connection? I mean, it's just an interesting bit of information, Michael. She dated Drew Carey, a well-known figure. Do you think that this jury will ever even know that? Yes, she had a conversation with him or messaged him 2 days beforehand, but to what degree do you think the state would want that information in there? And I'm sure the defense wouldn't mind it because it just adds another human being into the mix. But do you think Drew Carey comes in at all here?
Absolutely. I think he's going to have to. I think he might even testify, and I'll tell you why. The timeline works out where she dated this accused murderer before she basically became famous and elevated herself and became engaged to Drew Carey. What they're going to probably show is that he became very jealous when she had her own reality show, and when she got onto the Braxton reality show, she started, she got engaged to, Drew Carey, and then all of a sudden the prior ex-boyfriend, who she had a domestic abuse situation with, became very jealous, and he kept coming back and back and back. They're going to have to bring in Drew Carey. They're going to have to put him on the stand and ask him, hey, did she ever complain about this guy? Undoubtedly, she's complained about this guy to her fiance, because she was engaged to her fiance after she had all these incidents with this gentleman. So, I mean, undoubtedly, they're going to bring him in for sure.
All right, well, we'll look forward to that. Another wrinkle in this case. We'll see it all play out of Los Angeles there in that jury selection process. Started it last week, actually. We expect opening statements tomorrow. Kelly Hyman in Miami and national trial attorney Michael Jaafar. Michael, to you first. This 911 call, we talked about it last week. The judge said, no, you can't play the call unless you find the woman. And if you find the woman's voice and bring her in, fine, we'll talk about it. But at this point, you're not playing the call. Is that something that could pick up some traction?
Not really. It's not enough. I took a lot of flack from my colleagues when the prosecution rested their case, when the state rested their case, because I predicted she'd get convicted before the defense put on her case. I said, there's enough. They've met their burden. And I can't see how the defense is going to overcome that burden. So that 911 call would not have, in my opinion, would not have made a difference, because what's going to happen? Think about it. The detective testified that there were no prior incidents between these two. She had never called the police for help with this situation. She had not, this is the first they've ever heard of her and her situation with the victim, right? And so what would that 911 call could possibly have said? It would have been hearsay. It would have been somebody other than the defendant, the victim himself. So I don't see how it would have made a difference, and definitely not enough to overturn this. Look, the judge clearly did not agree with the jury. The jury made their decision, but the judge clearly did not agree with their decision. Because you saw a woman walk out. When I saw her walk out with her kids, I thought, wow, I was wrong. She got acquitted. And then I read more. I was like, well, she actually got convicted, and she's walking out on a sunny day. I've never seen this in 17 years of practice. I'm sure it has happened. It happens in situations that are very unique, but not like this. I've never seen that.
Yeah, sometimes it's a white-collar scenario where the judge will allow the individual to be out during pending the appeal, but we've got a knife, bleach, fishing, he stays in the car. A lot of the facts we know about the case seem to be coming out through this little boy. Michael Jaafar is watching along with us. This is a bench trial, so a jury would have trouble parsing what the child is saying out. How about a judge, though? How much credibility will a judge, do you think, give this youngster's recollection of events? Because, frankly, a lot of it does sort of fit into the state's theory, but on the other hand, every now and then he throws out a zinger that just doesn't seem to make any sense.
Well, I mean, anytime your case relies on the testimony of a minor, you kind of hold your breath and because you don't know what to expect. But to answer your question, it was a very intimate decision to waive the jury and ask for a bench trial. I've said on this show before that, one of my first felony trials was a rape trial where I had a co-counsel who was a former retired judge. And he advised me, I was a young kid at that point, he advised me, he said, we're going to waive the jury on this one. Trust me. I debated it. I said, that's a terrible mistake. I was young. I'd been an attorney, I think, for a couple of years. And it worked out. We got an acquittal because that former judge saw the evidence. He saw the facts. He knew exactly how it would play out. And he told me, if it plays out this way, this judge is going to be better than a jury. And he was right. So to answer your question, the way this judge is going to look at it, I have to assume that the defense attorneys knew that this was going to come in, and they made the calculation that a judge would be better for their client than the jury. So we still don't see the balance of it. The attorneys already have, but it's very, 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 very bad for the defense. The defense must have known that this was going to come. They must have made the calculation that a judge will probably parse through it a little bit better than a jury.
We know the lake where she was found, Breasia, was about 30 minutes away from the apartment. And the kid says it was a long drive. I don't know. I wouldn't be able to take you there because it was too long of a drive for him to remember. So that part of it fits. I was told to stay in the car while he goes fishing, but he never saw him with a fishing rod and never saw those other 6 people that he was supposedly fishing with. I mean, the kid's telling a lot of it seems to really match up with the state's case.
It does. It does. It's, again, the defense attorneys must have known that this was going to come. They must have predicted it. They must have seen it and grasped for it and told their client, we're going to have to waive this jury. Because, look, here's the thing, right? When you lose a case and you're a defendant, you spend the rest of your life stewing on your case, and people tell you, hey, the only way you're going to get out of here is if you claim ineffective assistance of counsel. Well, the first thing you're going to say is, my lawyers advised me improperly by telling me to waive this jury. It doesn't matter that I waived it, I signed a disclaimer, I did it based on their advice, right? And that's why I'm sitting here, right? So these attorneys would have sat down to their client's face and behind their client's back and thought, are we going to do this? We know the right way to do it, but we know that this is a big risk for us, but we know the evidence that's going to come in. And as you said, Ted, right, this kid's examination is falling right in line with the evidence around the case, right? And the guy looks like a villain, right? So this is not going well for the defense. But these attorneys, I'm looking at them in the courtroom, not right now, but before, and they are very, very, very nervous, and they are very focused because their butts are on the line. They're going to have to explain to future clients why did they waive a jury in this case. They have an answer. We just don't know what it is.
Yeah, good point. Let's get a break. Get you back to the courtroom for more right after this. Stay with us.